Well, hello, everyone. Thank you for joining us on today's webinar, Insights from Capitol Hill, the TCPA and the CFPB. I want to start by thanking our hosts, Contact Center Compliance, who are the organizers of the upcoming TCPA Compliance Summit in Chicago, and that's coming up in July. And I want to thank them for giving us the opportunity to provide content for today's session. I want to kick it off, actually, noting that there is an error on the slide that you're seeing. And I'm going to say it was left there intentionally, and that's my story, and I'm sticking to it. But the CFPB is now known, for those who don't know, as the BCFP. Now, the slight change was made, I think, about a month ago, and issued by the Bureau to signal a new role that the organization will play. And I think that exemplifies the shifts and headwinds that we see in the regulatory environment with the new administration. And so I am very excited today to have the guests, our special guests. They are legal experts. They don't like to call them experts, but they're well known. And our organizer of our Contact Center Compliance Summit as well. Now, my name is Stephanie. I am from LiveVox. We're a Contact Center Compliance Solution Suite. What we want to talk today about that we will provide is that, as Contact Center Solutions, we speak every day with folks that are in your shoes. And we speak every day with industry leaders such as Joann, our special guest, to get a better understanding of where the regulatory environment falls. Now, just at the end of the month, last month, Joann and Mark attended a special event in DC, and in that event we had Mick Mulvaney, the CFPB, now known as the BCFP Director, along with legislative leaders and industry leaders gathered to discuss the headwinds and the future of the regulatory environment. And so what we want to share with you today is insight from the two that have attended the event to see what folks are talking about. What will be the future? What is the direction? And most importantly, we hope that you take away some insight on how to move your operations or your businesses forward in the next 12 to 24 months. Now, since two of our three speakers today are legal experts, so lawyers, they have asked me to give a disclaimer. So I'm going to run through this, and it goes. The presentation and the statements of the panelists today do not constitute legal advice. We urge businesses to consult with their own experienced legal counsel to independently review the topics covered on today's event and independently evaluate any compliance measures they undertake. So, with that out of the way, I'd like to give a moment to our guest speakers today to do something a little counterintuitive and brag a little bit about themselves and share with you guys who they are and what they have done in the industry. So with that, Mark, I'm going to kick it off with you.
Thanks, Steph. Appreciate it. And thanks, everybody, for joining. My name is Mark Mallah. I'm General Counsel for LiveVox. Been here about 7.5 years. As Steph said, we speak to customers, pretty much every day about compliance issues. So I've been very immersed in the whole, compliance endeavor, TCPA, FDCPA, CFPB, BCFP, whatever the latest name is. And I'm glad to be joining Joann as well.
Thank you, Mark. Joann? Oops, apologies. Joann.
Oh, and Ryan.
Oh, hello. And Ryan.
Thank you, Stephanie. That was a great reading of the disclaimer. I think you could probably be on one of those car commercials. So, thank you so much. I'm very honored that you asked me to join Mark and Ryan today to talk about what is going on in DC. I am with the law firm of Clark Hill. I was a litigation attorney for a long time. I try to shy away from litigation as much as possible now. I give it to other people, but most of my focus has been on the regulatory environment, certainly in the last 5 years since the CFPB and the BCFP is around. I'm going to call them the Bureau throughout this webinar so that we don't have to worry about whether we're calling them the right name. So we'll just leave it to the Bureau. But I've been certainly in the debt collection space for almost 25 years, pretty much got into it right when I got out of law school. And it has taken a lot of weird paths because the industry has changed so much. And as we know, back in 2010, 2011, when the Bureau came, that was just a complete disruption of the industry. So I've been following the Bureau for a long time. since its inception. I've been before them, excuse me, representing clients before the Bureau, also engaging on behalf of clients with the Bureau. So I'm really excited about the discussions that we'll have today, and thank you for allowing me to attend.
Thank you. Ryan?
My name is Ryan Thurman. I'm the Director of Sales over here at Contact Center Compliance. I've been in the compliance space here at DNC.com for 14 years and several months. Got my start here right when the Do Not Call list was kind of coming out, back when there was a heck of a lot less numbers on it. Fast forward today to today's world, really we're helping our clients solve issues surrounding TCPA, where a lot of companies are looking for one vendor to kind of put cell phone ID, litigation support, reassign phone numbers, contact verification under one roof. And we've been running a lot of case studies about who some of these litigators are that we're running into, that we're tracking in ways to prevent TCPA issues from individual to class actions that I think you'll find interesting today in terms of some of the trends that kind of will illustrate to some of the folks some known actors, but also some unknown actors, and just for people who really aren't really seeing these folks, I think it'll look clearer in terms of what some of the dangers are out there. And interested to hear what's going on from Capitol Hill, from Joann and Mark as well.
Thank you, and again, thank you guys for joining. We know that all three of you, especially Joann, is a road warrior, and so we appreciate the time. We're excited to talk about what the state of the regulatory environment is. And as you guys heard, Joann is pretty active in speaking with folks, not just from a business perspective or an operations perspective, but with folks on Capitol Hill themselves. I believe she just came back from a meeting with one of those members. And so we hope, Joann, you can share a little bit of your secrets with us and what the discussions are like with some of the regulatory bodies. And so if you can give us just, again, disclaimer, said and done, if you can give us some insight on what you think the state of the regulatory environment is.
Sure. I'm trying to think of the right word. I would say it's disruptive right now. Clearly, as of November 24th, when Director Richard Cordray resigned, the Bureau has gone through a little bit of an implosion. So like everyone on the call saying, well, is that a good thing or a bad thing? I think it's a little bit of both. Certainly, our industry, since the inception of the Bureau, has had a lot of challenges with this particular regulatory agency. It has been extremely heavy-handed. People have said that it is, some of their activities have been overreach. And that really stems from the Dodd-Frank legislation, Title 10, which created, ironically, what was called the Bureau of Consumer Financial Protection, which is why Mr. Mulvaney has changed the name. That's what's written in the statute. It is not the CFPB, but that's what it was called, and it was given a tremendous amount of power, in my opinion. And the way the statute was written was the way Director Cordray ran the Bureau. He felt, through his interpretation of what the duties and responsibilities were of that agency, that he could do a lot of things. And he did. And he clearly, from day one, disrupted a lot of the financial services industry. We saw a lot of what we call regulation by enforcement, going into companies prior to certain rulemakings and saying that activity was unlawful, interpreting laws a different way. We've seen guidance, the Bureau issuing statements of how companies should act. And the expectation based on just that guidance is that companies had to follow it. For the what we call the ARM industry, accounts receivable management industry, for the debt collection industry, for companies that deal with call centers that are reaching out to consumers on a daily basis, this was really problematic. Many companies were subject to examination, supervision, CIDs. It was a hard several years to navigate. But in that time, clearly the industry stepped up, implemented incredible amounts of compliance procedures, invested heavily in compliance. And come 2017, we were definitely an industry that was compliant, focused on compliance, and wanted to stay within the bounds of the law. With Cordray's departure, the Bureau changed literally overnight. Mick Mulvaney is a conservative, strict constructionist, views Title X as having too much power, but is staying within, in his opinion, the bounds of what that authority is. But he's made some very significant changes. So to that extent, it's a good thing. But what I would say to a lot of people on the call is, just because we have someone who better understands our industry, wants to engage better with us, is not a reason to walk away from all the investments that you have made over the last 5 years. Because of the structure of the Bureau, as it stands now, in 5 years, you could have somebody very different again. And so you don't want to walk away from what you have built to only have to rebuild it again if there is a new director. So there is a lot of disruption. There has been a lot of changes. But interestingly enough, 10 minutes before we got on this call, the Bureau issued its first consent order against a company for debt collection and telephone calls. It just came out against a company called Security Finance Group. Basically, they do auto lending in many states, and they were doing in-person collections, which I don't know who does that anymore, but they happen to do it. And they were calling people at their place of employment when they were told to stop. So a $5 million consent order was just handed down today. I think the difference in that is what you've seen in the prior administration is that those are going to be the type of cases that the Bureau is going to go after, the bad of the bad, the clear violation, not the we're going to interpret unfair and deceptive, or even the CFPB or the or whatever consumer protection statute. I shouldn't say TCPA because it's not part of Dodd-Frank's authority, but FCRA. They're going to look at it very strictly. And if you go out beyond the bounds of what the statute says, the Bureau is going to look at you. So they're looking at rulemaking differently. They're looking at research differently. So I still think we need to be prepared and need to be very cognizant of what the Bureau is doing. But as I said, you've got, I wouldn't say it's a friendly ear, but you have someone who's willing to look at the Bureau differently and look at your industries differently. So I think that's a good sign.
Hey, Joann. So yeah, this is Mark. So yeah, good comment. So when we were there, I was struck by what Mulvaney said as far as you mentioned, the strict construction. And he did point out that we're not going away. We are still enforcing the law, and if there are bad actors out there, they will go after them. And I'd say so far, obviously we have a small sample size. He's been true to his word. If this consent order is any indication of that. So I definitely give him credit there. But one thing I wanted to ask you about, as the slide indicates, he is looking, as a strict constructionist, not to, basically to promote sort of the federal, system where we've got states, we've got AGs. What do you see as, what sort of activity, if any, do you see among the AGs? Do you see them as saying, oh, okay, we've got an opportunity here to step into the breach? Or, what are you seeing out there as far as that goes?
That's a great question. There's been a lot of talk about that because, as the slide shows, at a conference, I think last month or the month before, he said, the states know better than we how their consumers are being treated. And so he encouraged AGs to take a greater role in enforcement as opposed to the Bureau itself. And I think a lot of blue state AGs will take that comment to task. The problem is that when it comes to resources, the Bureau they have no budget. I mean, under the Cordray administration, basically the Fed was their ATM. So whenever they needed money, they just asked the Fed for money. They did have budgets, but you know, last I saw in 2017, I think their budget was somewhere about $600 million, which is an awful lot of money. State AGs don't have those kind of budgets. They will go after, I think the AGs are going to be forced to go after the baddest of the bads. Baddest of the bads are kind of easy targets because it's pretty clear cut. And there's not a, you know, other than investigation, there's not a lot they have to do as far as enforcement goes. But one thing I think that this audience needs to be cognizant of, what AGs do well is work with other AGs. And there's a lot of multi-state investigations. There has been multi-state settlements over the years. You all recall the JP Morgan Chase many years ago regarding mortgage, not only origination practices, but servicing practices. Look for AGs to work closely together to get multi-state settlements. I see that happening so they can kind of coalesce on resources and manpower to kind of do big hits. And I definitely see that happening. But again, I think it's going to be on clear-cut baddest of the bad practices.
Well, that's encouraging because it reminds me what Mulvaney said. And when he said this, I think he was really making a pointed departure from where the Bureau was previously. He said, you know, if we don't like what you do, but it's not against the law, we're not going to go after you. And I think he was implying that, you know, under the previous regime, if they didn't like what you did, whether it was illegal or not, they were going to go after you. So if the AGs really only have the resources to go after the baddest of the bad, then hopefully that will mean that it'll be going against, going against bad actors who are actually violating the law versus, hey, we don't really like what you're doing, we want you to stop, and we're going to put a lot of pressure on you to do so, and we're going to make you spend a lot of money.
Correct.
So
I think that's absolutely correct. I think that's absolutely correct.
Thank you. I mean, we could go on for hours just on this topic, and I think you mentioned a couple themes that kind of carry through. And you know, one of the biggest issues is, as we talk to our clients, is not essentially in partial, big part, right? What is considered compliant and what is not. It's the fluidity, it's the vagueness. So just the fact that you started out with the description or the word disruption, I think, you know, is a little bit counterintuitive to what I think people had initially thought, for better or for worse, because I think for clients or contact centers or BPOs who have multiple locations, adapting to any type of disruption, good or bad, takes years. And once you adapt to that, and it changes again, whether it comes from enough consumer outcry or another shift in the administration, the lag time between what is considered compliant and not is really hard to match the range or the speed of disruption from the legal side. So I want to carry that concept over to disruption around one of the avenues that have been, I think, of most concern for not only the financial services, but contact centers who lead in any other space. Cellphone outreach. 3 years ago, I think the stat says 70% of the U.S. population was cell phone only, and I can only imagine that has increased even more so. And if you are not targeting perhaps a demographic that is slightly older, you may see an even greater density of folks who are cell phone only. So, you know, the TCPA obviously was a major disruption, and there's disruption upon disruption. And so, Mark, I would like to give a chance for the audience to hear this disruption of the disruption and the latest disruption.
Thanks, Deb. After, Joann and I were in Washington and having an opportunity to think about this a little more, and also thinking about this webinar, I thought it'd be interesting if the TCPA were sort of analogized to diplomatic and military and political history.
I think some folks would already say that they're already in that bucket, Mark.
Yeah, sure. So I'm going to, mix some metaphors here and introduce some, again, military and diplomatic analogies. Joann earlier talked about weird paths. Ryan had mentioned trends. And I think there's been basically a recent note, 5 main eras or epochs. So the first one, not reaching too far back, was, I'd say, March 2013 to July 9th, 2015. And that was sort of this pre-war period. Started with Nelson versus Santander. We had this capacity question. Hey, what does capacity mean? Is it actual or potential? There was a split among the courts. It was important to separate, if you got a preview dial, to separate that from your automated dial. We started to see anxiety levels increase as a result of that decision. I know here at LiveVox, we got a lot of customer calls about, hey, what does this decision mean? What do you have? Are you compliant? Are you not compliant? And we started to see this emphasis on risk reduction. Then we had the cataclysmic event, the July 2015 order, the FCC order, where they took a very broad view of what's in ATDS. There was this expansion of capacity. They resolved that question. Does capacity mean actual or potential? They said it means both. And basically they came out with this very consequential order under which pretty much anything can be an ATDS. After that, we sort of had this post-war period from July 10th, 2015 to March 15th, 2018. During this period, we saw multi-million-dollar judgments and settlements, 15 million, 20 million. There was even like a $76 million settlement with a cruise line. We saw a flurry of litigation. Anxiety levels increased exponentially. Certainly following that ruling, I know here at LiveVox, we were on dozens and dozens of calls a month with customers, working with them to try to help them, interpret what had happened and adapt and use us in a way that hopefully was compliant. Further emphasis on risk reduction, given the tremendous exposure out there. And then there's this adaptation, to the new reality of the 2015 ruling. Then we had a subsequent cataclysmic event on March 16th, 2018, the DC Circuit Court decision. That basically deposed the ancien regime of the 2015 order, so basically amounted to a coup. That decision, of course, was not rulemaking, but it did give us parameters and certain contours. I would summarize it as the court saying, whatever you decide, FCC or courts, don't make every smartphone an ATDS. And then also, FCC decide whether an ATDS is random or sequential number generation or calling from a list. Can't be both. Now, I would put us again in this sort of pre-war period where we're in the wake of the DC Circuit Court decision. There's been attempted advances forward by, industry. So, for example, trying to get the definition of an ATDS limited to random or sequential number generation, trying to get predictive dialers excluded from the definition of an ATDS if they're not using random or sequential number generation. We've got the Chamber of Commerce petition to the FCC along these lines. We're also seeing, because the old regime has been deposed, but a new one has not quite been installed, we're seeing a lot of conflict among the courts. So, for example, were those earlier FCC rulings from 2003 and 2008, are they still valid or not? Courts are split over it. Predictive dialers, are they per se ATDSs or not? Courts are split. Is an ATDS limited to random or sequential number generation? Again, we're seeing split decisions out there. While that's happening, I think the FCC is trying to feel things out. They've requested comments on the interpretation and implementation of the TCPA. Today is actually the deadline for those. So I think they're trying to feel the situation out. And at the same time, we're seeing some potential blowback from this court decision, the DC court decision. So, for example, there are bills right now in the House and the Senate that are very similar, where what they've done is they've taken out ATDS and they've replaced it with robocall, which I think is clever because nobody likes robocalls. So if you're going to vote against this bill, they're going to say, well, you must be for robocalls. So they're trying to change the landscape here. In these bills, the burden of proof is on the caller to prove that the call was not a robocall. That's a change from today where the burden of proof is on the plaintiff bringing the case. In addition, there's this additional requirement in these bills to show that if you're making a manual call, that you have substantial additional human intervention. Substantial additional human intervention. What does that mean? No idea. This is an absolute breeding ground for litigation. So you got some potential blowback there. There's a bill in Massachusetts, H201 I think it is, prohibits all robocalls to cell phones. They do define robocall as a computerized auto dialer and a computer delivered pre-recorded message. So again, you know, we're seeing that there, and we got to look to other states to see what they're doing. So I think, you know, lastly, there's going to be down the road some more cataclysmic events, just as the 2015 order, the DC Circuit Court decision in March. I think the FCC is going to, you know, I don't know exactly when, but they are going to reissue, you know, an order to try to get it right based on the DC Circuit Court decision. So that's going to have, you know, very, you know, consequential impact. There could be another circuit court decision out there. I understand that the Ninth Circuit is looking at the case of Marks versus Crunch. So, you know, we have the DC Circuit. We could get the Ninth Circuit weighing in on this whole issue. We also have midterm elections coming up. So, you know, depending on what happens there, that could have far-reaching consequences. So again, I think we're sort of in this period of uncertainty. Forces are sort of gathering their ammunition, and we're going to see how this plays out.
Mark, I take that one. If anyone doubted whether or not our general counsel knew his stuff, I think he proved his point. But, you know, taking that analogy one step further, you know, it makes kind of our clients, contact center industry, special and financial services, feeling a little bit like refugees, waiting for direction as to what is happening next. And it sounds like we had hoped for some relief, but there was destruction upon destructions. And once again, there's a little bit of refugee status. There's some a path to some type of promised land, but we're not sure if that path is clear or whether or not it's going to change. To your point, Joann, in 5 years or in midterm elections coming up, will that shift? And that opens up a lot of vulnerability, being a kind of a regulatory refugee, if we're going to follow that analogy. And Ryan, I think you had some thoughts around what we're seeing upon this disruption.
Yeah, the interesting thing is that a lot of people kind of thought the good news coming out of the DC Circuit, or at least the somewhat perceived good news, would have an impact on case filings, and we have seen the opposite, which is prior to the DC Circuit order, you're probably seeing about 60 TCPA cases a week. We're seeing probably closer to about 80 of them per week now that we're tracking. We add about somewhere in the neighborhood about 1,500 to 2,000 phone numbers alone monthly into our litigator case file, our suppression tool of new numbers litigants are using. Of course, several of them use multiple phone numbers. But here's some of the ones that I've run into recently when I've been doing some testing with clients, which are kind of interesting. The first one was one I stumbled into, which everybody knows Craig Cunningham. He's a serial debtor, sues for FDCPA and TCPA routinely, pretty much on a weekly basis. The case I brought the screenshot of the docket is interesting because the case he filed, he actually crossed out one client's name and just wrote another company's name in there, so you can kind of see the old company's name. But the new one that he put in there was addiction intervention. Clearly, he needs some help. He claims he doesn't need help in the docket filing, which is funny. But it's just a good example of these guys that are just their cookie cutter cases. The funny thing about this case is that not only is he filing pro se, he also wants attorney fees and $50,000. So he's one that's a classic example. Lemberg Law, Everybody knows about him because I think he's the #2 filer out there. He's got an app. He's very dangerous. He's prolific. He's got a lot of people work with him. But he also has on his website blogs about companies that you may be getting calls from in ways that you can potentially sue them. So lots of collections companies that we're probably all on the call familiar with. Definitely worth checking out. The third one on here is another good example of Bhante Reuter Plumbing. These guys are quite the enterprise. They are based in Emeryville, which is not too far from all of us here in the Bay Area. It's across the Bay. And they essentially run a racket where they put out their cell phone numbers as business numbers, wait for companies to call them, companies that typically think they're calling under B2B context, turn around and funnel the cases to lawyers that are associated with them and file TCPA cases. And it's a whole setup operation where you get companies that you think are calling for services that a plumbing company might need, merchant services, credit card, cash advance, that kind of thing. And you get slapped with the TCPA lawsuit and it's caught quite a few people that I've talked to off guard. The other one down here, Melody Stoops, she's a classic example of a reassigned phone number case. If you Google her name in TCPA and go into Forbes, there's a great series of articles about her. She comes forward and basically admits that she uses this to fund her vacations. I haven't seen any cases from her in about a year, so she must have stockpiled a few because she's very selective about the type of company she goes after, mostly big financial, deep pockets, fairly interesting one. She's the one that keeps a shoebox full of phone numbers under her bed that she buys in specific low-income areas to wait for reassigned phone numbers, called or wrong party calls, sues under TCPA. This one on the bottom is fairly recent that one of my clients ran into, Jeremy Glapian. He did like 6 opt-ins on the same day on insurance websites, all to basically entrap a couple of clients that I work with through some of their affiliates. But he's fairly active. I would definitely keep an eye on that one. It's just good examples. This one on the bottom is probably one of the worst that I've heard of. I have attorneys on the defense side that won't even take cases against this guy because he violates settlement agreements, and he is very upfront that this is what he does for a living. If you call him, he sues telemarketers, he sues debt collectors. Based out of my hometown of San Diego, which puts a bad name with that, but just a few examples of some of these litigators that we're seeing out there. They don't seem to be dying down. In fact, the DC Circuit seems they had a very little impact, and they have really ramped things up. I mean, at least from what we've seen and what we're hearing in the industry. So,
hey Ryan, is Anton Ewing, is he an attorney or no?
He is. I'm not sure if he's an attorney. I think he is a. I'd have to look him up if he's an attorney, but I think he is a consumer.
Okay.
And so tying both analogies in disruption, there comes this state of refugee as we wait for direction, and in the state of chaos as a refugee, there are folks still out there who have actually ramped up a little bit of their predatory practices in hopes of capitalizing on this unknown status. And so, they're circling back to Joann. There's a lot of hope to create some path that is more business friendly, but at the same time, there still is a gap where there isn't, let's say, protection for businesses, right, to protect themselves against predatory folks who drive litigation. And so as businesses and their clients and Joann's clients who seek her counsel, you have to be at the ready as well, even if the regulatory trends, appear to be shifting in your favor. And so circling back to where we are with the Bureau and this disruption, Joann, I'm going to not associate disruption with your name, but maybe in a positive way. As folks look for,
My family says that to me all the time, so it's not a problem.
The people go to you to seek counsel and insight on all this disruption, because Mark went through a 5-minute history, and my anxiety levels went up.
Yeah.
Yeah. And so, what do you see the impact of the Bureau having on some of the agencies that are encompassed in that Bureau?
Well, let me definitely answer that, and let me also make one comment based on what you said. So, yeah, we do have a lot of disruption. I think Mark outlined it beautifully. I took copious notes. I will use it moving forward. But here's the good news, okay? I think there is some good news. I mean, if this was all happening 2 years ago, it would be a nightmare, because you've got an unfriendly Bureau, which a lot of, since the Bureau came to DC, everyone has kind of been following their lead. So they were definitely leaders of the pack. So can you imagine if all this was going on and then the Bureau making comments saying, oh yeah, absolutely, go after and do what you have to do? I think that would have been difficult. But so you have a change in the Bureau. At this moment in time, Mark did mention it, but we've got this little bit of window opportunity right now where you still have a Republican House and Senate. So the majority is still there. So you have people that understand, while to Mark's point, it was clever to put in robocalls, and nobody likes robocalls, but there is an opportunity right now to really be on the Hill, be engaging both at the legislative level and regulatory level about, you want to call them robocalls, that's fine, but really call it what it is, and that is an opportunity for trial attorneys to make a lot of money on a statute that is at this point become extinct and needs to be updated. So if that's the discussion, then let's talk about updating the TCPA, but let's not just give it teeth, again, giving a solution in search of a problem. So there's that. And then now, even though in my opinion, the FCC is kind of grappling with, oh my God, what do we do right now? We lost the ACA case. You have, again, a more industry-friendly FCC. You have, it's 3-2. And so that makeup is very different. Can you imagine going through this right now with the makeup of the prior FCC commission, who gave you the 2015 ruling, which was a complete disaster? So there are some glimmers of hope, but what industry needs to do is really kind of organize, whether it be, single businesses or associations, however it may be, to really set the framework of how you want to figure out the problems with TCPA, because there are big problems. And I will tell you, even with the, a lot of robocalls, which I just got one while we were on this call, the one thing I will say now, what I'm seeing differently in the last 6 months, frivolous litigation is something that people are taking notice of. And I will tell you at the Bureau, they're taking notice of it as well. That is something, especially in the debt collection industry, we've been complaining about for a long time, the ridiculous amount of lawsuits. The ridiculous amount of lawsuits under TCPA, as Ryan mentioned, should absolutely not go unnoticed. And it is something that has to be in the forefront of any discussion. Sure, we want to protect consumers, but all these TCPA litigation that we're seeing has nothing to do with consumers. Zero. Nothing. And so that's really where the focal point has to be. And that's where I think you're going to get the opportunities to really make change if you call it what it is. And those are, these are just litigation machine. These plaintiffs' lawyers that churn out these cases. I mean, they don't know who their clients are. These are factories that are just churning out and doing some real harm to businesses.
It's true. Hey, Joann, do you think we can get Ryan up on Capitol Hill and testify to some of these?
Why not? Vacation.
Why not? I mean, I think Ryan knows his stuff better than anybody. And that's the thing. I mean, it's a different, I always, maybe I'm looking for the silver lining here, but as I said, can you imagine us having this discussion 2 years ago? It wouldn't have been pretty. I mean, can you imagine going to the FCC, you know, with trying to, you already did that once in 2015 and it didn't work out too well. So we really gotta, I think that the FCC is really, there's a lot of cry for help there. And I think that we have an opportunity to bring some reasonableness and some logic to this, to the situation, which, you know, went on deaf ears in 2015.
You know, and Joann, following on that concept of the silver lining and trying to push legislation who may be a little bit more open, who by all signs are more open to hearing feedback. What we see on the right-hand side of that slide, most challenging CNC requirements, but what we get from our clients is one of the biggest issues is this silo, desegregated, yet varying laws. And with the exit of the federal taking a step back, you know, should they be more or less hopeful that there would be some standardizations around requirements as you cross state lines? Because a lot of contact centers, especially financial services, right, they just don't call within a certain state. They call within multiple. And so with the federal government being the way it is, and it's kind of more passive and providing the AGs more active roles, do you think that if our clients were to ask you, do you think that there would be an increase in standardizations of some regulatory requirements, or further away from a streamlined process? Because it's incredibly hard to manage, as you can imagine.
It is, and that's probably the biggest. So on the federal level, as I said, you have some glimmers of hope. On the state level, it's going to be tricky. I mean, while we were on this call, I just got an email from somebody. There's a bill that just got introduced in New Jersey, trying to define an ATDX. So they're coming fast and furious. And the issue with standardization is, yeah, we would all love a federal standard because call centers don't just call in one state. They're all nationwide. But states have the ability, have always had the ability, to enact laws that are stricter than what the federal standard is. So that is going to be a challenge. So while we talked about, when we were talking about the Bureau and AGs stepping up, now more than ever, I would say, is an opportunity to really engage your AGs on this issue. We talked about limited resources. Are they going to go after robocalls? I don't know, but we did talk about them all trying to doing, you know, multi-state investigations. But it's really important for this industry right now, the call center industry, to be engaging their AGs to make sure that because AGs can have an impact on state legislation, very much so. And so educating them and making them aware that a strict TCPA type statute in one state could be extremely harmful to business. I mean, if one state says, you know, you basically can't make any calls, well, guess what? That company, if they're based in that, either based in that state or they're not going to do it, and it's going to impact businesses. And one thing I will say about AGs, they do take their constituents, they look at their constituents very carefully, and in this type of certainly economic environment with business growth and competitive states competing for business, that's an area that we need to explore.
Right.
So I looked up Anton Ewing. He is not a plaintiff or not an attorney. He is a consumer, and he's actually been convicted of mortgage fraud and some other federal offenses, and comes up on ripoffreport.com. And yeah, these are the people that are, you know, using TCPA to line their pockets, basically.
Right.
So this, I left a little stammering because I think, you know, I think a lot of folks do kind of feel, hopefully, if I can encompass it or confused, still disrupted. But there does sound like there's a glimmer of hope, Joann, and you're at the forefront of pushing that type of advocacy, it sounds like. And as we work with our clients, we do the same. Now, I tell Mark all the time, and I am adamant about Joann, and so you, Ryan, so that at some point you would think that the shift in the regulatory environment meant that you all can take vacation. But it sounded like you guys are busier than ever. And so, you know, if there was some advice that you would give in all your busyness that you have collected, what would that be for those on the call? Because I assume that, and I'm looking at it, and the majority of the folks on this call are not per se from legislation or attorneys, and really hopefully not predatory consumers, but folks who have the wonderful charge of leading their operations or their business, navigating through this disruption. What would be some advice that we can leave them with at the end of this call? And I'm going to start off with Joann, and then I'll go to Mark and close out with Ryan. So Joann, if you were to take vacation, if ever, yeah, what would you tell your people, or what do you tell your folks?
A couple things. I think I've kind of said it throughout. I think engagement right now is really important. So you really got to know, you've got to know who your AG is, you've got to know who your state representatives are, you got to know who your federal representatives are, and you need to make them known about these issues. You need to educate them. And Mark was correct. I read through both those bills. They are relatively identical. There's a couple periods and paragraphs that are different. They are poorly drafted. I actually did a red line of the current TCPA statute and what the amendments would be, and there's a lot of gaping holes and things that are missing. So there's this, we're in we call it now silly season. We're in election midterms, and people are just trying to throw a lot of stuff out there to make a name for themselves. And it is so important for you to educate the people who govern you, because there's a lot of misinformation out there. And if that's one thing, you know, how you want to spend your summer vacation, communicating with these people, maybe put one-pagers together, you know, TCPA real facts, TCPA truisms, you know, what auto dialing means, why is it so important to communicate with consumers? Something to those lines. They have to know the reality of the world in which you all live in, because they're hearing a different story and they're reacting to that different story in not a very good way. And let me also mention too, you know, FCC, you can always, right now there's some public comments going on, but FCC will meet with anybody. You know, agencies, that's their job. So get in to meet with these regulators, and again, tell them the real story. Tell them what they don't know, because there's a lot that they don't know.
Right. And Joann, you seem to know a lot. And I think it is because you spend so much time. I mean, part of it too is that you know, I see you playing a very unique role, and you do so for us here at LiveVox, is that the myriad of stuff that happens and the speed that happens is really difficult for businesses to stay in front of it. And so unfortunately, Joann, I think that you may not be able to take vacation because you are the one trying to streamline everything for that. And I just want to say thank you from LiveVox as well for helping us guide through that as well.
The internet is a blessing and a curse, so it's very hard to take vacation. I will be vacationing, but of course I will be having my laptop. So thanks. That's very sweet, Stephanie. Thank you very much. I appreciate that.
And Mark?
Yeah, so, you know, I think Joann's advice is excellent. You know, engagement, you know, I think it's just excellent advice. I would just add to it or supplement it basically by saying that, you know, as I started out on this call, you know, I've been here about 7.5 years. And one of the things that I've seen here is that, you know, this stuff is never settled. You know, there's a case that brings some clarity, and then there's another case that casts doubt on the clarity that the previous case provided. So we're in a very dynamic environment. One thing I remember from law school many years ago, a professor said the law is a process. So wherever we are today, it's not going to be that way, proverbially or metaphorically speaking tomorrow. So I think it's very important to monitor the environment that you're in, do the engagement like Joann said, and then also, this is an art, the art of risk management, and sometimes it has to be practiced very exquisitely, given, the different rulings and regulatory decisions and things like that. So, again, I think it has to be finely calibrated at times, other times not as much. But, you got to sort of, keep your ear to the ground, gather your intel, engage, like Joann said, and then, see risk management and risk mitigation ongoing art and practice. No one out there is going to be able to achieve perfect compliance. This environment just does not allow for it. So you've got to, take a look at what your business goals are and what your operational realities are and make that balance between, productivity and risk management and risk mitigation and just do it on an everyday basis.
Right. Thank you, Mark and Joann. And it's one of those things you to recap, you have to be at the forefront of some of this knowledge. And Joann and her group are actively working, I think, to streamline that. And when Mark talks about calibration, it's this introduction, another silver lining is that innovation has moved almost just as fast as some of the regulatory shifts. And so there are a lot of empowerment tools out there. We at LiveVox, of course, have risk mitigation tools in our pockets and have been successful at it. And so along that side, there are more tools as well that our clients utilize, that the industry has made available with them, aside from in conjunction with CFPB and TCPA risk mitigation. And Ryan, what would you offer some of the audience on that?
My feedback would be that the days of trying to kind of handle compliance internally or even trying to build a dialer yourself really are just not worth it. It's not worth it to kind of try to do it yourself. You really need an expert. These cases that come up with these serial litigators, they can be costly. Just an individual case, you could be looking at settling for $30,000, which is pretty average. You get into a class action, you're talking 100,000 on up to $1 million. And the other thing is to really look at not just the basics of the law, but where some of these litigators are exploiting things, which is industries that think they're otherwise exempt, B2B calls, political calls, even some of the nonprofit stuff that's out there. Also to be kind of proactive in your attempts to keep your data updated. Phone numbers change. Ownership changes much more frequently than people realize because carriers are short on numbers. Younger demographics, millennials and below, they don't hold on to their phone numbers, especially in the debt collection market. So you really need to know how you're tracking for reassigned phone numbers. Also, verification of people that you're getting their contact information is also important. We've seen some cross trends with some of the litigation cases where the litigators use deceased individuals' names, they use falsified information, so really need a way to check that out. Other thing is another common theme I've heard from clients who run into issues is that, hey, we were doing everything right, but we worked with this affiliate over here, and they're the ones that caused the problem, which goes with that whole vicarious liability issue with TCPA. So you really want to make sure you know who you're working with, know that they have good compliance practices, make sure you can audit their data or require them to use a specific scrubbing platform or something that you can control. And then the last thing is just find ways to stay updated in this information, either by tuning into webinars, which gives you a good snapshot, but another way would be to come to something like a compliance summit like we're hosting in Chicago in July, that LiveVox will also be participating in, where you can kind of not only hear from experts, but hear from other people that are in your industry, in your verticals, that you can hear how they're handling some of these things and get some best practices that you can take back to the office.
That's great, Ryan, and thank you. We also look forward at LiveVox to be part of this compliance summit, and ditto on trying to stay abreast. There are forums out there. There are folks like Joann out there who can give you advice. There are tools out there, and so as things fluctuate, being proactive out there continues to be a theme that if anything has become even more true. And so we are trying to create some content to help streamline some of that information for you. And we hope that today's session was of interest. We really do want to thank our speakers. I think we just caught Joann right off her plane, actually. So we really appreciate your time, Joann. And if you do want to reach any one of us, we will be sending up some follow-up emails with access to this, along with some information about the Compliance Summit coming up in July in Chicago. So with that, I'm going to end the session, and thank you, speakers, for joining us. That was actually cool. We hear a lot of webinars, and that was really, really quite interesting to hear some of that insight. So thank you, Mark. Thank you, Joann. Thank you, Ryan.
Thanks. Hope everybody have a great summer.
Take care.
Thank you.